repeat so I agree with most of it. I think that, I think it's true, but we can't forget the composition of Congress when the abdication of responsibility took place in terms of the hard questioning and the control of the Senate at that time. But I agree that the conversations about what the court should do have been very defensive on the part of Democrats, liberals, and I don't know if we have 2 or 3 progressives in Congress, maybe. So, I mean, that's a hard that's a hard one to talk about. What the progressive questioning could have been at those nominations. But in the public, I think it's true that even in the public sphere, there's been that the right was able to equate the kind of constitutional decision-making that we need to have on the court. Somehow they managed to equate that with their ideology of small government and anti-regulation. So there was, less government, anti-regulation, reduced litigiousness, all of that got lumped together. And the court was one more place where government or people that were interpreting what government didn't come, with congressional statutes and stuff, had to get out of the way. Basically, they won the battle of saying that the court's role was basically to get out of the way, rather than to be a place where the final decisions get made about the structures in our country that make a difference in people's lives. And at the risk of being mundane, I want to, if you look at the last 2 Supreme Court terms, there have been cases on whether you need a photo ID to vote. You've had decisions about campaign financing. You've had decisions about whistleblower protection. You've had cases about whether the EPA should issue regulations about emissions. You have had cases on the Ledbetter case on pay equity for women and when you could file. All cases that I think anybody in this country, and this is what the election in a sense was about, knows that those are things that matter to them directly. And the court is the final say on all those matters. I know some groups have tried over the last 8 years to talk about the court in everyday people's lives. And I think that's really what we do have the chance to do with Sotomayor. I think the opening of even Obama's introduction of her as a person that has empathy and came up, the hard way, allows her to perhaps speak to the average American and talk about the court and her philosophy on the court from that perspective. I think it's also going to be very interesting that we've just had this murder that occurred 3 days ago, and it's going to put front and center, I think, that these issues that get talked about in abstractions on the court are not abstractions, and that this language, that's even this legal language, has consequences in real life to the point of a murder. So I'll stop here because I think we're going to talk about what questions we think should come up in the hearings, and I think that also goes to this issue.
So I'd like to, I guess, add and maybe amplify a bit what these 3 panelists have said. To me, to go to or try to address the question specifically, why should we care who sits on the court? Well, certainly from a worker's perspective, as someone at the AFL-CIO and who's devoted my professional life to representing workers and unions, it matters because the Supreme Court, quite frankly, will speak and have an effect on workers' lives going forward that will affect all of you, will affect you and all of your families. We are on the cusp of, I think, a new wave of social legislation that will, in many cases, wind up in the courts. The Employee Free Choice Act is pending in Congress. There's been quite a bit written about it. I believe that it will be enacted this summer, and I suspect that in one way or another, it will wind up in the courts. Who decides those cases? Who decides whether the statute is enforceable as written? Makes a difference. And if that winds up before the Supreme Court, we want somebody sitting there who will understand what it means to be a worker, who understands what it means to have an employer create working conditions that are intolerable, and based on their own life experience, as well as the way the statute is written and the intent of the statute, will issue a ruling that will uphold the intent of the statute. This isn't really fancy, I think, on our part. I think that the past is prologue. I think President Roosevelt, Franklin Roosevelt, was confronted with this in the 30s. I'm sure you all remember, or from your history, or that his first wave of New Deal legislation was overturned. And it took a threat to pack the Supreme Court to finally get the court in line and start having those statutes not be declared unconstitutional. We did a study. Marge mentioned that we've studied the impact of party identity on the courts and court decisions. We did a study of starting in about 2001, 100 union victories before the National Labor Relations Board, and what happened to them when they went to the Courts of Appeals, which is the first level appeal. And we found that where Republicans sat on the panels, we lost about 80% of those cases. They were either not enforced outright, or they were reversed or remanded for further hearing for some reason. These were cases where hundreds of workers had been fired years before, where they had come together and over threats of discharge, or in some instances, occurrences of discharge, had successfully formed a union, only to have that election overturned. So it matters. For those in the disability community, I suspect that they would tell you that the Americans with Disabilities Act, when passed in 1991, was a wonderful statute, and they approach it with great hope. Unfortunately, a very conservative judiciary effectively gutted that statute. Right? This is now only 18, 19 years ago, to the extent that the statute has largely been rewritten through the amendments that were enacted last year. The Ledbetter decision that was referenced. I don't think anybody could have envisioned a decision like that 25 or 30 years ago. So we think it matters who sits on the court, messaging or no messaging, because ultimately these people will bring their life's experiences to bear, and if their life experiences is that they come from a corporate background and don't understand what the purpose of the social legislation is, they'll be less inclined to enforce it in favor of workers.